Right now at 5:30, attorneys for lawyer-turned-convicted killer Alex Murdaugh filed a lengthy and long-awaited appeal.
So it comes after a decision from South Carolina Supreme Court to allow a judge to decide if Alex Murdaugh should be granted a new murder trial over a claim of jury tampering. So the 56-year-old now serving a life sentence for fatally shooting his wife Maggie and youngest son Paul in June of 2021. So it happened on their family's hunting estate in Colton County. Prosecutors argue that their murders were an attempt to distract from Murdaugh's mounting financial crimes. But in the more than 132-page appeal, Murdaugh's attorneys argued that the financial crime should not have been included in the murder trial. The appeal also alleges that former county clerk Becky Hill swayed jurors to find him guilty. Chief Legal Analyst Clive Rhodes joining us now.
All right, so Clive, let's talk about the claim of jury tampering here. What do they think could have swayed jurors in this case?
Well, first of all, the jury needs to be protected. Think about a newborn baby. Think about, a dog that you just don't want to have anybody come into contact with that short amount of time when they're first born. You don't want anybody having any contact with them, and then you kind of expose the dog to other dogs or to other people. It's the same way with a jury. They have to be protected, incubated, isolated, 100% isolated. That's the goal, to make sure that no one can tamper, no one can speak with. I'll give you an example. My judge would say anytime we'd have a trial, you may see the attorneys walk right by you and ignore you. Don't hold that against them. I've instructed them to ignore you purposely so that they can't even look at you in a funny manner. That's how far judges go to protect those babies, which is a jury pool. And so when you're talking about what could have happened, Becky Hill, for instance, was saying, don't believe him. Don't believe anything he says. He'll try to convince you. He'll try to put those eyes on you and make you believe what he's saying is true and make you believe that what they're saying is a lie. So because she was planting that seed in their head, that's one of the things that they're talking about. You're also talking about the evidence that was presented by the prosecutors even throughout the case of the trial. You mentioned 132 pages. Yeah, there's a lot of things they're pointing to, but the jury tampering, specifically Becky Hill's comments, her misdirection, her persuading, all of that are valid points that I would clearly make if I was making this appeal.
All right, 2 points. Jury tampering and the jury. Let's talk about that. There is now a former juror who put out a book. And so now that we have this insight, she specifically talks about that there was no jury tampering. Can that help her go against Murdaugh's appeal?
Well, I think that those are contradictory statements. So I'd say I don't think that it would hurt, even if that juror says that she did not or he did not observe any type of jury tampering. It's already stated on the record that Becky Hill made these comments, that these allegations that they have alleged in the 132-page complaint or appeal, I should say, have already been made. That's uncontradicted. The question is, were the comments enough to sway their opinion? And when the judge oversaw this first hearing, that was the question. Outstanding was, even if you heard these comments, even if you heard this persuasion, were you persuaded? Did it have an influence on your decision? And the jurors unanimously stood up one by one and said, no, Your Honor, I was not persuaded. I still would have made the same decision. They're appealing that, basically saying that, no, that's not true. You could not have still made the same decision, and why it's mounting evidence that said you should not have made the same decision.
When you take a step back and look at this entire appeal, I mean, as an experienced defense attorney, what is your take on it? But adding to that, Murdaugh already pleaded guilty to the financial crimes. He's serving 40 years for that. He's 56 years old. He won't get out until he's 96. Just with this alone, why bother?
Well, I'll take it back to my first job out of law school, or I should say my last year of law school, working in Fulton County Public Defender's Office, talking to the public defender of the county. She said, sometimes our clients are guilty, and we know that when we first meet them, we are recognizing that we are still defending justice, that our job is to make sure they're not railroaded and the prosecutor doesn't do something inappropriately. In this situation, some things were done inappropriately, his defense team believes, and so they have an obligation, a duty, to present a case to ensure that their client isn't railroaded.
I'm with Morgan. The math ain't mathing for me.
It's hard to imagine going through this all over again. It was a circus the first time around.
Well, sign up for the second circus.
Thanks, Khalif.